equal protection of laws for both men and women alike. Law is not different for a man, law is not different for a woman. In a situation, in a given case, law applies equally for both a man and woman. This is what Article 14 of our Constitution says. Article 15.1. What does Article 15.1 say? The state shall not discriminate against any citizen on grounds of religion, race, caste, sex, place of birth, or any of them. So, there cannot be any discrimination between a man and a woman on the ground of sex, on the ground of gender. Man and a woman are equal. Article 15.3. This is an interesting article which plays a major role in the field of women empowerment. This article can enable the state to make special provisions relating to women. The state to make any special provision in favor of both women and also children. That is what Article 15.3 of our Constitution says. Then Article 39A. The state to direct its policy towards securing for men and women equally the right to adequate means of livelihood. A man and also a woman has a right for adequate means of livelihood. It's a right which is equal to both a man and a woman. There is no discrimination here, even as per our Constitution. Article 39D. Article 39D speaks of equal pay for equal work for both men and women. So a man's work for a fixed period of hours and a woman's work for a fixed period of hours, the same duties assigned, there cannot be any discrimination insofar as remuneration is concerned. Article 42. The state to make provision for securing just and human conditions of work and maternity relief, a special provision made under the Constitution for the well-being of women and keeping basically women's welfare in view. Then we have Article 39A. What does Article 39A say? Article 39 capital A says that there cannot be any denial to a woman for securing justice. So Article 39A promotes justice on the basis of equality. So man and a woman both are equal. 39A provides for establishment of legal services authorities. They are institutions which provide free, competent, effective legal services to the downtrodden, poor and the weaker sections of the society. So a woman cannot be denied her opportunity of securing justice on the ground of economic or other disabilities. Section 12C of the Legal Services Authorities Act 1987 provides for free legal aid to women, which include free, competent, effective legal services to the woman. So any woman is financially weak, she is not in a position to engage a lawyer, to pay for the professional charges of a lawyer, can always approach the Legal Services Authority, which is an institution established where taking care of the case of that particular individual, a legal aid counsel is assigned and she will put forth the case without charging a single rupee from that woman. Section 12C of the Legal Services Authorities Act 1987 provides for free legal aid to women, which include free, competent, effective legal services. Likewise, Articles 243 D3 and D4, they provide reservation in panchayats, and Article 243 T3 and T4 provide for reservation for women in municipalities. Now, I would like to refer to few judgments, simple judgments, because you're all young children. I cannot. The court defined sexual harassment and observed as under: each incident of sexual harassment of women at workplace results in violation of fundamental rights of gender equality and the right to life and liberty. The said judgment provides for lodging of complaints of sexual harassment by any woman employee to a complaints committee created in the employee's organization for redress of the complaint made by the victim. This is significant The committee in turn advises the victim on further course of action and recommends to the management of the course of action against the man accused of harassment. This verdict later led to the enactment of Sexual Harassment of Women at Workplace Prevention, Prohibition and Redressal Act 2013. So whenever there is any instance of sexual harassment, there is nothing to worry. You can always open up and explain to the committee constituted and speak to the higher heads in the institution. There is another judgment, Vadaboyana Tulsamma. This is a case where the apex court held that section 14.1 of the Hindu Succession Act 1956 must be liberally construed in favor of females. This section makes female Hindu a full owner of a property and not a limited owner. Secondly, the divorced wife, the state work board established under the act should ensure that the maintenance is paid to the divorced wife. This case of Daniel Latif very well speaks that the maintenance should not be confined only to the iddat period, and it becomes a duty that the divorced wife is entitled for maintenance, and in a way the relatives are not in a position to pay. The state work board has to take up the responsibility and pay to the divorced Muslim wife. In Mrs. Mary Roy's case versus State of Kerala, reported in 1986 AIR SC 1011, this case held that Christian women are entitled to have an equal share in their father's property. This path-breaking judgment sent shock throughout the country, and better still, the ruling granted equal rights to Christian women with retrospective effect. So everywhere the law, the judgments of the apex court are in aid of women. They are helping the woman whenever the woman rushes for justice. In Lata Singh's case versus State of Uttar Pradesh, that's a case where it was an intercaste marriage under the Hindu Marriage Act, and the court felt that the girl was a major, the girl was not a minor. The court said that the couple cannot be harassed, the couple cannot be troubled. They are entitled for their life. And the court even said that the police should institute criminal proceedings against persons who threaten, harass, commit, or instigate acts of violences on people who decide on intercaste or interreligious marriages. In D. Veluswamy's case in the year 2010, the Supreme Court in this case held that live-in relationships will also come under the purview of Domestic Violence Act 2005. In Roxanne Sharma versus Arun Sharma's case, the Supreme Court in this case held that in a battle between estranged parents, where custody of a minor child was the issue concerned, the division bench held that a child cannot be treated as a chattel, and the custody of the minor child shall be allowed to remain with the mother. In Seema versus Ashwini's case in the year 2006, the Supreme Court in this case directed the state governments and the central governments that marriages of all persons who are citizens of India belonging to various different religions should be compulsorily registered. What is the most common nowadays? Young girls. An NRI comes, marries an young girl, and thereafter he deserts her and goes abroad. By compulsory registration of marriages, this can be stopped. The whereabouts of the NRI can be traced, and their efforts can be made to see that justice is done to the poor girl who believes in a dream that she has a life abroad by marrying an NRI. So this is a judgment are not put to hardship. Center for Enquiry into Health and Allied Themes versus Union of India. In this case, the Supreme Court issued guidelines to prevent female feticide. Of late, whenever they see that the pregnant woman is carrying a female in the womb, in most of the cases, the girl is crucified even before the girl child is born. So to check this, the Supreme Court has given this judgment. In Dr. Upendra Baksi's case, the Supreme Court in this case treated a letter as a writ petition. Matter pertained to the conditions in which girls were living in the government protected. The superintendent of the protective home was directed that no woman or girl is detained in the protective homes without due authority, without due process of law. The district judge Agra further nominated two women advocates who would in turn visit these protective homes once in a fortnight and inquire about the welfare of the young girls there. In Shaira Banu's case, you all know about it. All the young girls sitting here know about this. The Apex Court on 22nd August 2017 decided the issue of triple talaq and set aside the said practice by a 3:2 majority. In Valasamma's case, in 1996, the Apex Court said that human rights for women comprehends gender equality. The Supreme Court explained that all forms of discrimination on grounds of gender are violative of fundamental freedom and also their human rights. In Bodhisattvam Gautam reported case in the year 1996, this conferment of equal status on women, apart from being a constitutional right, the Apex Court recognized it as a human right. I'll just read the words how the Apex Court explained. The Honorable Apex Court observed about women as follows. Their honor and dignity cannot be touched or violated. They also have a right to lead an honorable and a peaceful life. Women in them have many personalities combined. They are mother, daughter, sister, and wife, and not playthings for the center spreads in various magazines, periodicals, or newspapers. Nor can they be exploited for obscene purposes. They must have the liberty, the freedom, and of course, independence to live the roles assigned to them by nature so that the society may flourish as they alone have the talents and capacity to shape the destiny and character of men anywhere and in every part of the world. This is the view of the Apex Court insofar as women are concerned. Women cannot be discriminated.